Hello, I'm Rodger Citron. I'm a professor at Toro Law Center. This is a Toro Law Review podcast, and we're delighted today to have as our guest Alicia Bannon. Um, she is the director of the Judiciary Program at the Brennan Center for Justice. We're going to find out a little bit more about Alicia and what she does in a minute. But first, I just want to let everyone know that we will be talking about a very timely topic, judicial elections, and of course, the role, the influence of campaign contributions and political donations in that context. So, Alicia, thank you so much for joining us today.
Thank
We
you so
begin.
much for having me. It's a real pleasure.
Thank you. And we begin with, the obligatory, tell us a little bit about yourself.
Sure. Well, so my name is Alicia Bannon. I direct the Judiciary Program at the Brennan Center for Justice at NYU Law. And I'm also the editor-in-chief of State Court Report, which is a publication the Brennan Center launched last year dedicated to state courts and state constitutions. I've been at the Brennan Center wearing a bunch of different hats for a long time, more than a decade now. But one of the through lines of my work has been studying and doing advocacy and public education around state courts, and now more recently, state constitutional development. So it's something very close to my heart.
Thank you. And I'm a civil procedure professor, which means I'm a federal civil procedure professor. And of course, right now, I think we're in the second week of school, at least in Toro. So in setting up federal and state courts, of course, both courts are important, but there is a tilt or a focus on federal courts. So I have to start with, why do state courts matter?
Well, and I will say, I think law schools should be spending more time teaching and covering state courts and state constitutions. So that's my call to action on this podcast, because state courts are really important. I think, a lot of people don't know 95% of all cases in the United States are filed in state courts. So they are where the vast majority of people whose lives are being directly touched by courts, that's usually happening in state court. And they're very powerful institutions. When you look at, questions of state law, state constitutions, typically state Supreme Courts are the final word in interpreting state law and state constitutions. So, for example, if there is a case under a state constitution's Eighth Amendment analog, so their state constitutional provision around cruel and unusual punishment, if what that state Supreme Court does, what they interpret that to be, typically you're not going to have then an appeal to the U.S. Supreme Court. That state Supreme Court is going to be the final word. And so they're very powerful institutions in a whole bunch of arenas. And that's, even more so as we've seen the U.S. Supreme Court in a number of arenas kind of stepping back from certain kinds of rights protection, like in the reproductive rights arena. That's brought state courts really to the fore. So, they've long been under the radar, but I think it's something where people are starting to pay a lot more attention to state courts and recognize the potential power that they have.
Can I ask, did you come to your interest in state courts, state constitutions, as a structural matter, that is, in your interest in sort of federalism and the role of states and state courts, or did you get there in effect by, in a substantive route? That is, that there was an area of law that it turned out that the action or important action was taking place in state courts. I'm just kind of curious how you, arrived at this particular passion.
That's a great question. I think it's a little bit of both. I think that, from very early in my career, before I was at the Brennan Center, I was, involved in litigation in state courts and, saw both justice in those courts and frankly sometimes injustice in those courts. And it made me really interested, for example, in how things like judicial elections can shape judges' incentives, impact their behavior. I was long struck that these were really powerful institutions that were really different than the federal courts in a lot of ways, and that there wasn't as much attention to kind of understanding the significance of those differences, particularly given the importance of those courts in people's lives. I think certainly more recently with the changes on the U.S. Supreme Court, also as that court has become more conservative and has rolled back rights in key arenas, I think that's a place where, I think that's been noted obviously much more broadly than by me, but I think that's really highlighted both the substance, the role that state courts are playing in protecting particular rights, but also some of the structural aspect that you're raising. The fact that we do have a federal system where states can come in, the U.S. Constitution is a floor, not a ceiling, and states play this really important role in our broader democratic system as additional bulwarks for certain kinds of rights.
Yeah, and in your answer, you touched on something that I know we're going to dive into, which is the fact that in many states, judges are elected, and there may be some lay people listening to this. And so, how is it that in many states, we elect judges because sort of a fundamental divide is, oh, law and politics, and without trying to resolve that debate, how is it that, in fact, we elect judges, that is, through this political process, just like political officials, such as the governor or legislators?
It's a great question, and the U.S. is pretty unusual in its system of electing judges. There are, at the state Supreme Court or the state High Court level, 38 states use elections as part of their system for choosing judges. That can include states that have contested elections where multiple candidates are, competing for a seat. Sometimes those are partisan elections where there's a party label on the ballot. Sometimes they're nonpartisan. And then there are states that use what are called retention elections, where a judge is initially appointed to the bench and then they stand for a yes or no vote. So you can kind of boot them off the bench if you want to, but they don't have an opponent. And in terms of what's the history? Why do so many states have them? It's actually really fascinating. At the time, at the time of our country's founding, there were no states that used judicial elections. So all states, judges were either appointed by the governor or by the state legislatures. And judicial elections came later in the 19th century. They were largely seen as a reform actually intended to enhance judicial independence. So the idea was that you had judges, the concern was that judges were too closely tied to the political branches. And so the way to make them more independent was to make them more accountable to the people. And so, that originally you had partisan elections adopted, then you saw a reform surge to introduce nonpartisan elections. Then later you had other reform movements that introduced these what are sometimes called merit selection systems, where you have judges initially appointed with the assistance of a nominating commission and then standing for these up or down retention votes. But it's a fascinating history that I think kind of gets at some of these deep questions about how we, about choosing judges, because at least in the United States, basically all of these processes are political in one sense or another. And, the courts are a branch of government. They're part of our politics, but we obviously don't want judges to just be politicians in robes either. And so what the trade-offs are with these different systems of choosing judges is really complex. And, I think one thing we've seen recently with judicial elections in particular is that over the past 2 decades or so, we've seen them become more and more politicized. And so this line between judging and politician has often, gotten blurred.
I want to sort of, as they say, bracket a question or park a question, which is that I wonder if any of the different ways of selecting judges at the state court system that you described, if any is better than any other. But let's hold on to that, because I think there's sort of more to tell before we get to that question. And when you say that, essentially this century, the the election process, even for judges, or the election process for judges, has become more politicized. What's your sense of why that has happened? Is that a polarization story? Is that, I know at some point we're going to get to Citizens United. I don't know if that's a Citizens United story, if there's other parts or pieces, but, why is it that there is this, sort of greater intensity or greater politicization um, with respect to judicial elections and judicial selection?
It's a great question, and there's not a single answer. I think there have been a couple of phases of ratcheting up. So judicial elections, we started to see more politicization before Citizens United. So it's not only a Citizens United story. I think you started to see a couple of examples of really high cost political elections in the 90s, and then it really blew up in the early 2000s. I think largely it's a story of the tort wars becoming the court wars. So you had a number of state Supreme Courts that struck down under state constitutions various forms of tort reform and other ways to try to make more, kind of hospitable business climates in particular states. And that attracted the attention of the Chamber of Commerce and other business-oriented organizations that started to put real money into judicial elections in an effort to shift the composition of courts in a more business-friendly direction. And it was something where, until that time, these races were very sleepy. You saw virtually no money. They were just, generally very, very low profile, low salience races. And, we saw this initial influx of money. Originally it was largely coming from business interests. You started to see some spending on the other side from plaintiff side trial lawyers, again, the other side of the tort wars, to some extent unions as well. You saw some spending from political parties as well. So that was maybe the first phase of it. Then came Citizens United, which interestingly didn't actually change as much how much money was being spent as it did how it got spent. So until then, most of the money that was going into judicial elections was going into candidate contributions. So people were just giving money directly to candidates. After Citizens United, which opened the door to unlimited independent expenditures, you increasingly saw that money going into outside groups that weren't subject to disclosure. So you could have sort of rise of dark money, also not subject to judicial codes of conduct. So various ways that judges are restrained in how they can campaign. These independent groups aren't. So that contributed to a kind of ratcheting up of the politicization, the tenor of those races. And so that was, I'd say, phase two. And then I think we've most recently entered a new phase, which I would say is a post-Dobbs phase. So when the US Supreme Court overturned Roe v. Wade, that brought much of the battle over abortion rights into state courts, state constitutions. And that has tremendously raised, I think, the salience of at least state Supreme Court elections among the public. And we've seen since Dobbs, record-shattering spending in the judicial races that we've seen since then. Most strikingly in Wisconsin last year, where more than $50 million was spent in a race for a single seat. It was a very important seat. It had the potential to flip the ideological composition of that court.
Yes. No, I was gonna. It's the O'Connor or Kennedy seat of Wisconsin that was an issue. But the uh, a couple things. One is I just wanted to I believe Citizens United was 2013. We can check that afterwards, but I just wanted to let people listening have a sense of the unfolding or the chronology here. That is when we moved from into phase two of Citizens United. And then the second thing was, I think you wrote an article, a law review article in 2018, and it totally caught my attention what you said about post Citizens United. It didn't strike me that that would be either obvious or intuitive that, oh, the amount of spending didn't change that much, but the source did. And I guess two questions. One is, why? That is, why is it that instead of sort of, it being the sum increasing, it sort of stayed the same, if you have any sense of that. And then the second one uh, is that, if you want to call it trend or development, that you described in 2018, still more or less true today, to the extent that or
Well, so I think that in terms of the why, I think what's interesting is that if you looked, a number of states had already fairly weak campaign finance regimes. So, there were some states where, there were very, there were not major limits on contributing to candidates. There were, not even necessarily, because remember, these are state races, so they're not federal, they're not subject to regulations of federal elections. These are all state elections. My sense was that in a lot of states, the state campaign finance regimes were already somewhat lax, but what changed even more so than like formal legal changes post Citizens United, at least as it relates to judicial elections, was more of a cultural change where, you had it normalized the creation of these outside independent expenditure groups. And it, in response to these changes in the federal legal landscape, at least, there was also a lot of infrastructure created to support these kinds of independent expenditures. And that then got essentially inserted into these state judicial elections as well. In terms of is the trend continuing, I think now we're starting to see more spending. So I'd say post Dobbs, which was 2 years ago in 2022, we've seen not just more outside or independent expenditures, although we're seeing a lot of those. So in the last election cycle, which was 2021 to 2022, there was a record amount of independent expenditures. So nearly half of all the spending in state Supreme Court elections across the country was done by outside groups, not by the candidates. But then we're also now just seeing a lot more money come in. And we're also seeing it from both sides. So for a very long time, the spending dynamics were pretty asymmetrical. Not in every state, not in every race, but we tended to see a lot more money coming in support of conservative candidates, Republican-aligned candidates. Mostly that was coming from business interest, as well as from kind of more nationally oriented groups that were maybe also engaging in judicial selection controversies at the federal level. But if you looked at who was supporting more progressive or liberal or Democratic aligned candidates, it was not nearly as much money. And that is changing. So in this last election cycle, we basically more or less saw it parity. And I think we're seeing similar trends so far this year, where there's, I think an increasing attention among groups on the left to these state Supreme Court elections as well.
And just a quick follow-up question. The last election season where you noticed this parity, was that the 21-22 election season that you were referring to?
That's right. So the Brennan Center, we have tracked for many years, basically since the year 2000. So well before I came to the Brennan Center, we've tracked spending in state Supreme Court elections. And so that's let us look at these trends over time. And so we usually do it in these two-year cycles. Almost all of that spending took place, though, in the November 2022 election. So even though it covered 2021 to 2022, it was really a post-Dobbs story. And then since then, now we'll be putting out a new analysis after the 2024 election that'll cover last year and this year. And already in 2023, there were two major state Supreme Court elections. There was Wisconsin, which I mentioned, which was completely record obliterating, more than $50 million spent. But then we also saw a major election in Pennsylvania, more than $20 million at the end of 2023. So I think we're already seeing in this newer cycle those trends continuing.
And that's real money. I mean, 50 million, 20 million, in a state election is real money. And so, you know, how how has this increase, this influx of real money into the judicial elections that we've been talking about, what's been the effect of that? And I know there's a number of ways to sort of examine that question. Um, Perhaps we start with what's it meant for the operation of the judicial system? And then we can sort of expand out to what it means for litigants and the public. Can we start there?
Yeah, I think it's a troubling trend. I think that there is a good amount of, I'll say, I think most judges are trying to do their jobs in good faith, and they're trying to apply the law as they see it. But I also think that our election pressures are real, and I think can be very hard to put those kinds of pressures aside when you're hearing very high stakes, high salience cases. There's been a good amount of political science research that suggests that election pressures can impact judicial decision making. Judges sentence more harshly in election years. There's evidence that, if you look at judges' behavior in terms of, are they voting in similarly aligned to who's contributing to their campaigns, that those correlations exist, but that when judges are facing mandatory retirement ages so that they're not going to have a future election, then those correlations disappear. So it's like it's the election pressures that are actually impacting the judicial behavior. And I mean, I think when you think about it, it makes sense. It's hard to be looking over your shoulder when you're deciding a case, wondering, how is this going to play out in front of the voters? How is this going to play out in front of my major campaign supporters? And so I do think it creates a real pressure on the system, and a real pressure when it comes to the role of judges, because obviously judges are not supposed to be taking into account those considerations. They're supposed to be looking at the facts and the law in front of them and deciding cases according to what they think the law requires.
And one of the things I think that's interesting about what you describe is, right, it can affect criminal cases. That is the pressure to appear strong on crime or tough on crime. Um, uh, and then, of course, it can also affect civil cases. In fact, much of the history I think that you recounted is actually far more concerned, it seems, about developments on the civil side as opposed to the criminal side. Is We can start to sort of move out, if you will, and what does it mean for lawyers and litigants, and then really what does it mean for the public? And I wonder whether, is it even sort of part of the political consciousness that it shouldn't be this way. It's too close to, compromising values of neutrality or objectivity, what we associate with law, so that in effect it's, we're turning state courts into another set of elected political officials. So again, multiple questions. I'll stop with a compound question now.
Well, I think you're absolutely getting at a lot of the complexity here. I mean, one just point when you were talking about the dynamics in criminal cases and civil cases, one element of that I think is really interesting is that if you look at what the most salient campaign issues are, often they're about criminal cases, often, unfortunately, misrepresenting judges' rulings, in a criminal case. So this judge was soft on crime. They let a child molester go free, even though, it might have been a case that was about, the Fourth Amendment, but that's not how it's framed in the attack ad. And so you see a lot of attack ads focused on criminal justice issues, and also positive ads, people touting their records as tough on crime. If you look at where the money comes from in a lot of those ads, it's actually coming from business interests, but they're not putting out campaign ads saying, vote for Judge Smith, he's going to, support big business. They say, vote for Judge Smith, he's going to be tough on crime. And so I think that's one of the complexities. And I think why, even when a lot of the financial interests are focused on other things, the criminal justice issues are always very front and center in these races, and the impact on judicial decision making can matter quite a bit in the criminal context, even if that's not what the actual interests involved are most focused on. In terms of what it means for lawyers and litigants and for the public, I do think there's a real concern about public confidence in our judicial system, public confidence that people are going to get, a fully fair, impartial hearing on their cases. I remember several years ago, there was an election where there was a campaign ad where the candidates were touting that they upheld, it was, I might get the number wrong, but it was something like 95% of all death sentences. And it always just struck me, what would you say if you were a lawyer representing someone on death row? Or what would you say if you were that person, right, who had a case before that court where they're campaigning on the fact that they uphold all of these death sentences? What if your case would move them to 94%? Would you feel completely confident that you're going to get a fair hearing? I think it raises those really, really profound questions about fairness. The only other thing I'll say is that, as much as I think there are really serious concerns with judicial elections, I also don't want to give everybody else a pass. Like, I think that we've seen, a lot of politicization in other forms of judicial selection as well. I mean, I think we just need to look at our federal courts, and, obviously appointments can be very politicized too. And so, I think it's important to also think affirmatively about what kind of a system is most likely to engender public confidence and engender a court that's able to perform its job. And I don't think either of those extremes are doing a very good job right now.
Yeah, that's I think now, the question that we put in the parking lot, we could take it out for a spin. Because the how what would you do if you could, or what would you change if you could? And I guess obviously since we've been talking about, state courts and judicial elections in states and for state court offices, what would you do there? And I wonder whether any of the, different ways of electing or selecting state judges seems to you perhaps better than others.
So we've done some research and thinking on this at the Brennan Center, and I do think there are better and worse systems. There's no system that's perfect, and there's always going to be trade-offs around values. And I think different states can make different trade-offs around those values. But I guess I would highlight two elements that I think are really important to be thinking about with respect to judicial selection. One is that I do think that an appointment system with a strong, independent, diverse nominating commission does have the potential to really make a difference and turn the temperature down when it comes to judicial selection. The way these typically work is that you have a commission which is appointed by ideally appointed by a number of different actors. So it's not just a kitchen cabinet of the governor. The governor might get a few appointments, state legislature, members of the state legislature, leaders get appointments. Often the judiciary itself gets seats on the commission. There's often partisan balance requirements, things like that create a commission that's job is really to vet judges or vet judicial candidates in the first instance and come up with a short list that then goes to the governor. And the devil is very much in the details. But if you have a system like that really is diverse, that has broad representation of interests, there's been experience in states that suggest that, in fact, that can really lead to a high quality judiciary that's pretty independent and, not just not too closely tied with the political branches, not too closely tied to special interests. So I do think that these judicial nominating commission systems are worth serious consideration. The other piece.
Oh, sorry. And just while we're there on the nominating, what are some of the states that do that and seem to do it well, if I may? Yeah.
Of course. I would lift up Alaska has a very strong judicial nominating commission system. Kansas is another state. Hawaii is a state that's had a good system. New Mexico. So there are some examples. And again, no state is perfect. There's advantages and disadvantages, but I do think there are some models that have worked well in the states. The other piece of it, and I flag this because you can do this even in a state that has judicial elections, is to also look at the terms that judges have. So we've urged states to consider adopting a one and done lengthy term for state Supreme Court justices, rather than doing what almost every state does now, which is have some kind of reselection process. So either judges having to stand for re-election or retention election or reappointment. Almost every state, you have a series of terms instead of one long term. And everything we know about election pressures or pressures on judges suggests that it's that reselection pressure where the threats to judicial independence are most severe, because those are the dynamics where you're hearing a case and then worrying about your job security at the same time. And so another reform that we encourage states to think about is to just adopt, could be something like in the range of 12, 15 years, a lengthy term for state Supreme Court justices, rather than having them keep standing for new elections that are going to put those pressures on them when they're hearing cases.
And do any states do it that way with the one term and
we don't? There's one state, Rhode Island, that has just life tenure for its judges, and then there are two states that have retirement life tenure with mandatory retirement ages. So those probably come closest, but they're not a set term length.
And the other piece of this, perhaps we'll end here, but is the money piece. That is, the flood of money just gets bigger and bigger in the electoral process. And do you see any way to end that arms race?
It's difficult to see in the short term that money, that arms race ending. I do think there are things you can do to mitigate some of the harm that we're seeing from the flood of money. One thing is public financing for judicial candidates. I think one of the really pernicious elements of money, particularly in judicial elections, is that you don't want judges dialing for dollars. You don't want judges reaching out to the lawyers that are appearing before them and other people who have interests asking for money, or having their campaigns ask for money. And so I think a system of public financing that takes that pressure off of judges would be one thing to mitigate some of the damage. Another piece is stronger ethics and recusal rules. So one thing that I think most people don't know is that, in most states, there are very few limits on judges hearing cases involving major campaign supporters. And so, and that's especially so when you have these independent expenditures. Like, very few states have any recusal rules at all that grapple with spending by outside groups. And so I think that's another place where if you had strong recusal rules coupled with disclosure requirements that made sure that we knew where the money was coming from, then you could at least address some of the conflicts of interest that crop up when this money is coming into these judicial races, and then judges are actually hearing cases involving the very people that have been supporting their campaigns.
Yeah. Thank you. I want to just ask a sort of a catch-all. Is there any aspect of this that we didn't discuss? That is, is there any aspect of either the law or the politics or the possible reforms that you'd like to elaborate on that we haven't previously discussed? If not, we can end here. But thank you.
Yeah, I think all I would say is that something that has generally been the case, although this might be changing, is that judicial elections are usually pretty low information races. People don't know a lot about their their courts, who sits on the courts, who's running for these elections. And it's really important. These are really important seats of power. And so I guess I will close with maybe just a call to action to, for folks that live in places where there are judicial elections, to learn about the people that are running, to vote. If you're in a state that uses a nominating commission, they often accept citizen participants on those commissions. So think about engaging in those ways. These are important things, and they're opportunities for members of the public, for law students, for others to get involved, and it's important to do so.
Yeah, I think that's actually a great place to end, truly, because the possibility of civic engagement and civic involvement is always, hopeful, promising. And I'll end there. Thank you so much, Alicia.
Thank you so much, Rodger. It was a real pleasure.